You are welcome to yet another episode of HN What's Your Say? The leading listening show where we discuss important issues with important people like you. We are again featuring R. Kelly. Real name Robert Sylvester Kelly. Also known as the R&B King. The two federal courts which tried R. Kelly engaged in what we may refer to as courtroom malpractice and turned what was supposed to be a quest for justice into a kangaroo court process that did not stop at prejudicing R. Kelly, but that went on to cheat him of his well-deserved freedom in a number of ways we are yet to explain. The New York court which tried R. Kelly first saw over 40 government witnesses taking the stand, with most of them presenting numerous uncharged claims, which is alone an act of utter prejudice. Even the panel of jurors was constituted by individuals who had promised to prejudice R. Kelly when they were asked to mention the kind of person they regard the worst in society, and they mentioned defendants dealing with cases similar to R. Kelly. Some of them actually did admit to have watched the controversial Surviving R. Kelly docuseries, and were passionate followers of this mudslinging smear campaign against the R&B King. As if that was not enough, the New York court also chose to ignore the FBI report which suggested that the government, in conjunction with several Bureau of Prisons officers and blogger Tasha K, did enter into conspiracy to illegally access R. Kelly's prison communications with his attorneys and with his girlfriend Joycelyn Savage, a finding that should have called for immediate acquittal and dismissal of the case against R. Kelly. Remember, it is against the law to deny an inmate or detainee privacy while speaking to his or her attorney, and any act of this nature equals a violation of defendant's basic right to client-attorney privacy, which should have seen R. Kelly acquitted with prejudice. It is also against the laws of this land for government to break the law while trying to gather any evidence from a defendant, or to carry out any unwarranted searches in such a manner as was done with Kelly's prison communications. It is also during this New York trial that the court entertained the infamous RICO and Mann Act charges that have no basis, and that should never have been allowed on R. Kelly's charge sheet in the first place. These are the open-ended vague laws that have been misused by the oppressors since time immemorial to take down black American celebrities like they did Jack Johnson in 1912. Just like we mentioned in our previous video release, if this Mann Act law had not been used to crack down on heavyweight champion Jack Johnson in a way that caused President Trump to pardon him even in his death, and to declare that in fact the event took place during a time of racial struggles, perhaps we would give it a benefit of doubt. There is no doubt, however, that the very way this Mann Act was used to destroy Jack Johnson's career is the same way it's been used against R. Kelly. When it came to the RICO charges, which were supposed to have been dismissed the moment the prosecution failed to provide backing evidence of an illegal enterprise, the court, again by malpractice, chose to maintain these charges and issued a guilty verdict as well. Again, this only confirmed that the RICO statute was also intended to target the black American communities who were growing up in the projects, and that had the stronger likelihood to be part of a gang at one point in their lifetime. At time of sentencing, the New York federal judge ignored the defendant's plea for a shorter sentence and even issued 5 years extra to the 25 government prosecutors had requested. Until today, there are still numerous pending questions that demand to know exactly how the New York federal judge of Brooklyn, Ann Donnelly, came up with the 30 years like she was sentencing a serial killer, and how she made the decision to deny him probation before he completes the 30 years. According to Judge Ann Donnelly, R. Kelly can only be due for supervised release after completing the 30-year sentence. This was so unfair to imagine a man in his mid-50s deserved to receive a 30-year prison sentence for simply having a major fallout with his girlfriends, many of whom were way over the ages of 20 and a few, like Azriel Clary, claiming they met him when they were 17 and a half. This meanwhile cannot be proved with evidence, considering Azriel at that time possessed an ID that showed she was 18 and also confessed to lying to R. Kelly that she was an adult when they had just met. What's most weird about the trial phase when handling the case against R. Kelly, however, is the way the Chicago federal judge was quick to ignore the jury's decision to acquit R. Kelly and his co-accused of their obstruction of justice charges, and instead use his own inference, allegedly by preponderance of evidence, to suggest he knows R. Kelly did this. This deviation for his own jury's decision was not only shocking, but also an indicator that in fact they must have disagreed on so many things. There is therefore a high chance that all the decisions made in the Chicago trial court were a result of conflict between Judge Leinenweber and his jurors, as opposed to the idea of consensus. It's no wonder he was again seen influencing the decision to issue a verdict on enticement and coercion charges, where he said that a guilty verdict on one aspect was enough to justify the second, even though it was clear that R. Kelly did not in fact coerce anyone. The judge was simply following his own instincts and using guesswork as opposed to following the decisions of the jury. Just why would anyone conclude that a man who beat his obstruction case in fact did obstruct justice? The provision of decision by inference and preponderance is surely being abused here. While this is suited for civil cases where the standard of proof required is relatively low, when dealing with a criminal case, the plaintiff ought to prove every claim beyond reasonable doubt. But for the trial judge to abandon the jury's decision, which was based on the evidence arraigned before court, and opt for preponderance of evidence, Harry Leinenweber was out of order, and clearly that was a vote of no confidence in his own jurors. And that is why we are right to conclude that he ditched his team of jurors to satisfy his personal ego of having to use preponderance and pass a wrongful conviction onto R. Kelly. According to Mary Ray, "I can't believe that our government allows this kind of behavior to take place. How could Jack Johnson, for example, be charged and imprisoned for simply loving adult white women? And now R. Kelly for adult black women, and a few who claim were 17.8 years going to 18. Clearly adults in their states." Meanwhile, the government should solve this conflict between state and federal law by simply scraping out state policies. A single American citizen cannot become an adult twice. Once at 17 in accordance to state law, and later on at 18 in accordance to federal law. This alone is a trap intended to lock up our people. For a judge to apply preponderance of evidence and inference while making judgment in a criminal case should not be acceptable. According to Camoj Love, "Now I can understand that many people in the government of America hate Mr. Kelly for his talent without even knowing how to write and read. What I see here is jealous. The haters be thinking, how come we waste money going to school and someone just come make more money than us? People, please stop hurting Mr. Kelly. God gave him the wisdom and there is nothing we can do about this. We will never be the same in the world, so stop humiliating, harassing, sabotaging and framing him." If you wish to take part in a live interview on this channel discussing any of these topics, let us know by emailing us on sashahnnewsroom@gmail.com for scheduling. That is all we had for you today on HN What's Your Say? To keep updated whenever we post a new video, subscribe to this channel now. Also remember to hit the bell icon and enable notifications. And feel free to share your opinions with us in the comment section below, and let us know if you would like us to publish your views in our next release. We value all our subscribers' opinions.